I will fairly breeze through the presentation on licensing issues in IP. Essentially, what you try to achieve in the context of licensing IP is a bundle of rights, basically permission that's given to you by the owner of that bundle of rights to do certain things within the context of those rights that he owns. And those rights include things like patents, copyrights, biotechnology, industrial designs, utility models, trade secrets, semiconductor designs, and any other forms of IP where rights pertain to an individual or an organization based on successful application thereof. So when you're licensed to have the privilege to have those rights basically from the license holder, it basically allows you to either reproduce, to make, to sell, to market. Or in the context of patent, it allows you perhaps to actually practice that patent, to commercialize it, or to copy and distribute a certain kind of work. So the context of all those rights is basically I, as a right holder, telling you that this is my bundle of rights, go ahead and do the following things. The Industrial Property Act has been mentioned in a number of areas, but in the context of licensing, basically patent owners can actually do the following. In respect of a product patent, they can make, import, use, or offer for sale. And therefore, thus, when a patent owner licenses his bundle of rights under patent, then he allows you to make, import, use, offer, or sale, as the case may be. The requirements for licensing under the Industrial Property Act are that it must be in writing, and of course, it must be in the form of a contract, essentially. That has to be executed by both parties. It must be registered at the patent office, and if it's not, then there's no recognition, therefore, regardless of the fact that it will be a contract assigning a bundle of rights to you. Of course, the institute can deny you registration based on certain grounds, and some of those grounds include if I, as the owner of the bundle of rights, chose to or preferred to license them to you at excessive prices. Basically, I was quoting, the earth for you to actually access those rights for commercialization. Then there's a case there for the institute to actually deny the registration of that license, where the license serves to convey rights which may be harmful to the economic interests of the country. For example, you're seeking to license a bundle of rights in technology which is foreign sourced, yet the same is actually available locally and perhaps at a very affordable cost, then CIPIT does have a ground there to deny registration of such a license. Compulsory licenses can be issued, again, this is under the Industrial Property Act, for the non-exploitation, supply, or refusal of offer on reasonable terms. Again, these are things which are provided within the Act, and so I'll sort of just go to the next slide, since those are very straightforward and can be read in the context of the Industrial Property Act. Now, in a manner of speaking, licensing can actually be a means of generating additional revenue. Especially for a corporate. We spoke yesterday of patent trolls who almost have elevated this to a science in a sense. One of the interesting things that the US government has done is to introduce a Patent Troll Act. It's still a bill at this point, hasn't actually been passed into an act, but the whole purpose of that bill is to allow a defendant compensation where the court or the judge feels that the company that is suing you for infringement will not stand a good chance, will not have any success, essentially trying to place a barrier, trying to mitigate against patent trolls and the kind of behavior they exhibit by scanning around looking for individuals, organizations that they can take to court with a view to trying to make money. Licensing inventions is a very good thing because it does complement and enhance the business objectives and activate the value of technical knowledge. Sometimes what happens is you may have come up with a certain patent, you own a certain bundle of intellectual property rights, you do not feel like commercializing them, or you've come sort of to the end of the road in the context of your intellectual pursuit as far as that patent is concerned. And what would happen is you handing that over to another person who then can take it to the next level allows you to benefit at a greater level because once you license them and they have rights to invest the intellectual property upon that bundle of rights, it can actually take you to a whole other level where you didn't exist before. Philips, just by way of example, and there's loads of examples, has been one of the leading companies in the world by way of the kind of revenue they generate from licensing their IP. They have had, as of early 2004, about 100,000 patents worldwide. And some of the inventions, for those of you who might not be aware, include the DVD, JPEG, MPEG, Xenon, car lights as well. Now, essentially, when you get to a point where you have that kind of, those number of inventions, it does really make sense that you won't be able to, since you won't be able to commercialize all of them, or successfully commercialize all of them in as many countries in the world, it makes perfect sense to offer them on a license basis. I mentioned yesterday that you have essentially broadly two types of licenses. One would be the exclusive license, which then excludes the patent owner as well from commercializing, from developing, from practicing that bundle of rights or patent, as it were. It allows the licensee utter and complete rights even over the original patent owner. Where you have a sole license, essentially, you agree between the two of you, licensee and the licensor, that I will give you this bundle of rights, but perhaps what we are going to do is, if we're in East Africa, say, I'm going to exploit and commercialize my rights in Kenya, but you as a licensee can go to Rwanda, Burundi, Tanzania, Uganda to do that. And you sort of agree on territorial issues, volumes, and things like that. Cross-licensing is a very fundamental aspect of licensing, because this is what happens when peers, in a sense, peers come together and seek to actually innovate in a collaborative sense. And what it does is it promotes, like I've said a few minutes before, fertilization of ideas. It allows your ideas to be further populated by someone else. It allows sequential innovation, takes you to the next level. It allows you a competitive edge, because if I have a bundle of 100 patents or 100 sets of rights, and you have about 200, and what we do is come together within a certain region, you can see the kind of competitive advantage it gives you when you cross-license and allow each other to respectively exploit your rights. So it gives you quite a bit of competitive advantage and geographic exposure. The licensor has the benefit of both his patent and the additional information in the sense of how do you adapt the invention for differing purposes, because I may have, as an inventor, come up with a certain invention which was patented, and in my mind I had a certain purpose, a certain use for it. But if I license it, then you come in and you take it to another level where we're able to apply that patent or that right or the practice of it to a different use. And guess what happens? It just makes money for both of us, and the world becomes a much better place. But yes, like Gishuki said, it's not about money, I guess. It's about doing pro bono work as well. So cross-licensing minimizes patent fights. And this is a very fundamental aspect of cross-licensing. I think in the subsequent slide, we'll look at how Microsoft has tended to have an approach of we want to license you. We want you to license our rights from us. We're going to give you our rights, and we want you to give us access to your rights as well. And if you refuse to do that, then what they do is they sue you. But when you have people competing in the same space, cross-licensing, then it's obvious that there's going to be as minimal litigation as possible. What you require, and this is, I think, still essential even for one-way licensing, meaning where you have a licensee who doesn't have any rights that he'll be cross-licensing to the licensor, but you need to essentially understand how the technology is appraised, and that's one of the more challenging things, because you have to put a value to it before you arrive at the kind of royalties or fees or profit percentages you'll be paying to one another. You certainly need to have a level of assessment and exchange thereof. And once you arrive at an economic value, then you need to agree, am I licensing, are we cross-licensing the whole set of patents that we respectively own, or are we doing a portion of it? What is the validity period of the patents? Because if I'm going to license a patent from you, and it is valid for another 2 years, then it really doesn't give me lead time to do what I would like to do, perhaps to commercialize as much as I possibly can and raise as much revenue as I possibly can. And essentially, it's important to discuss the aspect of if it's only valid for 2 years and I still really want to license that patent from you, what sort of advantages will I get out of this agreement? Because at some point I'll suffer loss. Beyond the 2 years, other people will have access to commercialize that patent. In the smartphone and tablet industry, a lot of companies source technologies from a wide range of hardware and software manufacturers who produce a wide offering of consumer products. I've given examples there. Apple is one. In as much as Apple is having a big fight with Samsung today, it is true that they have accessed, they've cross-licensed a lot of the technology, a lot of the patents that they individually own in technology. Microsoft and Samsung entered an Android licensing agreement, and this followed on from a lot of fights. Naturally, the fights tended to be more from Microsoft's side. They tended to behave like a patent troll. But essentially, they arrived at a series of agreements, and the thrust of it was that Samsung would pay royalties for the Android tablets and smartphones that they're making, while they would help Microsoft develop their Windows device, their Windows phone that they're seeking to get into the market with. Microsoft has since had very many fights with other Android manufacturers. Essentially, the terms, the substance of what you need to cover in a licensing agreement will include the kind of fees, and we talked about those fees need to be arrived at following a valuation of the technology and pricing of those patents. You have to have, obviously, a very lucid description of what it is, what is a product, what is a process. A precise description then leaves less room for misinterpretation and therefore for lawsuits emanating from that license. The duration of the agreement, how the license will be terminated, how the agreement will be terminated, because inevitably they do come to an end, and especially if they come to an end on the basis of the end of the exclusivity that's given to you as a patent owner. So that needs to be agreed on. One of the dicey issues to deal with is where know-how is involved, and it's not essentially as tangible as a hardcore computer hardware technology. And the reason is, once know-how has been exchanged, once know-how has been cross-licensed, I can't sort of delete that file from my mind as an institution or from the people that I trained to take advantage of that cross-licensing. So once that know-how has been transferred, it's very difficult to say, erase that file. You can't utilize that know-how that you acquired. And even if the agreement came to an end, how am I certain that as a patent owner, that know-how is not being used or being made available to third parties? So there's some difficulty in that. Of course, your traditional confidentiality and non-disclosure provisions. Where the licensee improves on intellectual property, one tricky bit here is that if I was a licensee, I would prefer to certainly patent any further developments I would make on existent IP rights which were licensed to me. But if I'm a licensor, what I want to do is to make sure that you revert back to me and keep me updated. Let me know that you are sequentially innovating on top of what I licensed to you. That way then we can both benefit. But you can see that ideally it would benefit the licensee more than the licensor. And the licensee tends to acquire patents, would prefer to acquire patents separately. Ties between the licensee and the licensor. The licensor can insist that a licensee acquires non-patented goods and services directly from him. These are some of the arguments that a licensor will try to push, because it's in his interest that he retains a level of exclusivity, singular ties with the licensee. That way then the licensee is tied to him for whatever period duration of the license is. It's in the licensee's interest to acquire those bundle of rights, but still have the freedom to source other goods, products, or services from other people, because then he probably can acquire them at lower cost. Those there are very straightforward. The licensee and the licensor need to sort of come to an agreement on the level of protection in terms of royalty amounts. The licensor would rather ask for as much, an arm and a leg the licensee would rather pay as little as possible. So it's obviously a good idea. And it's very difficult, having said that, to get it right the first time. You'll sort of need to have clauses on renegotiation, because you have no idea on how successful that commercialization would be. You may find yourself not doing very well, and you're tied to a certain clause on percentages of profits or certain royalties, which then would cripple you and put you out of business. So it's pretty difficult. So ordinarily you'd have clauses that would allow you to renegotiate based on the level of success. Compliance with competition regulations is very, very critical, and it's just the next slide. But essentially, competition law is there to ensure that there's unrestricted competition at all levels, including within the context of licensing agreements in IP. So if you have a license agreement which divides a market and creates obstacles to trade, and that is the focus of competition law, then you will have a problem with the competition regulator, with the competition agency. But like I said, sometimes you want to have a very open-minded, forward-looking competition agency who will create certain unique and specific rules for licensing rights under IP. I've given there examples of different cases where competition law has come into play, not necessarily IP rights and licensing, but in the context of a licensing agreement, you could have tying or bundling. And in competition law, tying or bundling essentially is where I tie you to get your goods, to get your supplies from me and nobody else. And like I said, you can have an agreement with the licensee where the licensee shouldn't go anywhere else and should and must come to me. That infringes fundamental theory of competition law, where you have price fixing, where you have exclusivity, geographic resale restrictions. Those would fall foul of competition law, and like I said, it's important to have a competition authority who understands how to define the playing field in the unique case of IP licenses. The European community made certain block exemptions with regard to patent licenses. This is the kind of forward-thinking move I was talking about, where they have what is called a technology transfer block exemption. And what it does is to create new distinctions which are based on thresholds of market shares of the licensor and the licensee. And essentially, the licensor and the licensee cannot really be very, very huge companies controlling significant market share. In competition law, before the application of competition regulations, the market has to be defined. You have to define the specifics. You have to define the kind of influence a company has. But what the European community has said that it will be based on the position in the market of the parties, the licensee and the licensor. And will only be applied to licenses between the two parties and not to any larger arrangements involving either other parties or any agreements which would tend to be which would be exclusive with regard to geographic or goods exclusivity. Basically, under competition law, if you're found culpable, then you can be sanctioned with prohibitions, meaning you're stopped from doing certain things, certain behaviorals. You can be fined, you can be imprisoned, you can have damages imposed on you, and damages ordinarily, depending on how egregious the offense is, can go up to 10% of total revenues, global revenues of any institution. And that sums up the aspects of licensing issues in IP. There being